Welcome to Heather Sells NYC with your host, Heather M. Cooper. Each episode is focused on helping people navigate through the intricacies of buying and selling real estate in New York City to get the greatest value. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, heathersellsnyc.com. Now here's the host of Heather Sells NYC, Heather M. Cooper.
Hello. Welcome, Eric. Thank you for being here today. Really appreciate it.
Thanks for having me.
Wanted to introduce Eric Brecher, who is an attorney for 25 years and over 18 years of experience as a qualified intermediary for 1031 exchanges. Just a little tidbit of information, a fun fact, that there are only approximately about 130 certified exchange specialists in the country. Wow, that is amazing. And that Eric works for CDEC 1031 Exchange, which is a subsidiary of WinTrust Financial, which is a $50 billion bank and a top 30 bank in the country. Wow, Eric, what amazing credentials that you have. Thank you so much for being here. Welcome.
Looking forward to speaking with you, Heather.
Thank you. So, Eric, there's so much information that you can share about 1031 exchanges. I guess you could share with the audience about what does a qualified intermediary do?
Sure. So what my role is, a qualified intermediary, is a function that a client's own attorney or accountant or realtor, anybody that served as their agent over the prior 2 years, is not permitted to perform. So we're going to talk about 1031 exchanges and what they do. My role is, once a taxpayer has their property that they are looking to sell in contract, I then get involved in setting up the necessary 1031 exchange documents. And equally as important, I am required to hold the money from their sale and then help them navigate the critical deadlines that we'll discuss to identify and replace their relinquished property within the critical deadlines. And we also prepare documents for their acquisition. So that's the role of the qualified intermediary, what I have done for over 18 years. It's important to note that, as you indicated, I work for a subsidiary of a $50 billion bank. The reason that is important is, unfortunately, the qualified intermediary industry is unregulated. And we have seen Ponzi schemes, bankruptcies. There's an entire episode on American Greed on CNBC about it. So I'm uniquely positioned as a bank that, of course, is subject to government oversight, and publicly traded company for that matter, in that we're subject to government regulation. And, so we'll kind of close, I guess, a little bit with that as well. But yeah, so that's the qualified intermediary role. Right.
And I guess what we should tell the audience is, at what point, if I have somebody that comes to me and they said, oh, I don't want to pay. I bought my property in 1980 for $100,000 and now it's worth $3 million. So that would be the point of doing a 1031 exchange.
Yeah,
from your
perspective. Right. Yeah, we ought to talk about what exactly they are. So 1031 exchanges are part of the tax code, section 1031. They've been around for over 100 years. Right. And the reason they were put in the tax code back in 1921, albeit a different code section, is the same reason they exist now, which is to allow investors to continue their investment. And it allows a deferral of their taxes. So there's some things we ought to talk about. First and foremost, there are 4 statutory requirements. We are only talking about real property. Pre-Tax Cuts and Jobs Act, which went into effect in January of 2018, Up until that point, you could do 1031 exchanges of aircraft, of artwork, of other machinery and equipment. But post Tax Cuts and Jobs Act, you can no longer do exchanges except for real property. So that's sort of the first issue. We need to be talking about real property, and that's your business, and that's the business that I'm in. So that's first and foremost. Secondly, we have to have this notion of an exchange. So again, you cannot simply have a sale followed by a purchase. The sale has to be structured as an exchange. So we'll sort of talk about that a little bit. Very important that this real property that we are structuring an exchange for has to be held as an investment or used in a trade or business. So this is not for people's primary residence unless there is some investment component. If it's a two-family and they live in half of it, or it's a single family, but there's some accessory dwelling unit that is rented out or otherwise treated as an investment. So it has to be held for investment. There are some applications for second homes, vacation homes. They allow very limited personal use. They do require that there is some rental component to it as well. We can dig into that a little bit later if you'd like. And similarly, on the acquisition side, the replacement property, again, has to be real property. And their intent must be not to liquidate this investment or use it for personal pursuits. And that real property has to be, as we call it, like kind. So generally, all real property is like kind to all other real property. So again, you have to have real property, has to be held for investment. We have to have this structured as an exchange, and the exchange has to be for like kind property. So that's the spirit of a 1031. And of course, why people are doing this is to defer their realized gain upon a sale, which is a function of their, at a top rate, 20% federal capital gains tax, 25% depreciation recapture tax, their state income tax, and lastly, their Medicare net investment income tax of 3.8%. So
that sounds like a lot of taxes.
Yeah. I mean, give or take, typically you're looking at a third in taxes of your gain. So it's important to understand what the adjusted basis is in that property being sold. So that's usually a CPA question. It's the adjusted basis is what a taxpayer paid for their property minus depreciation plus any capital improvements. So once you have that adjusted basis and you subtract that from the sale price, you now have a good idea of roughly what that tax would look like. And the idea is, of course, not to recognize that gain, but to defer it by buying other investment property.
Right. Eventually, you're going to have to pay it. This is just a way to not pay it today. Correct?
Yeah, it is a deferral. It is a wealth preservation tool. The reality is that you can do exchanges over and over. It's not a one-time proposition. There are people that jokingly say you can swap till you drop. You certainly can hold any asset, and upon passing, your heirs will get a stepped up tax basis. And depending on the taxpayer's estate, perhaps there will be no tax due. But our data reflects that typically people are paying some tax either upon their initial relinquished property sale or in a subsequent sale, there is tax being paid.
Right. Yeah. So, what are you? So, I guess the question is, can you help anyone across the United States?
Yeah, so I handle exchanges, as I've done for over 18 years, and have assisted thousands of 1031 exchanges coast to coast. And I've been involved in exchanges worldwide for that matter. It is important to understand that there are essentially three primary strategies and benefits in doing an exchange. First and foremost, geographically. So you can exchange any property in the United States for any other property in the United States.
Okay, so
That
if
includes the
we
Virgin
do,
Islands, includes
Mhm.
Guam.
Oh, great.
Did you have any clients there? I'm sure that's a popular place for you.
So if somebody were to sell in New York, could they do a 1031 like in New Jersey or in Guam?
Absolutely. Absolutely.
Oh.
You can trade any property in the United States for any other property in the United States.
Oh, that's really
Similarly,
great.
any foreign property can be exchanged, but only for other foreign property. And I've been involved in some significant transactions in Europe. I've been involved in exchanges in Israel, Australia. So those don't come up obviously very often, but if a U.S. taxpayer that would be subject to tax upon the sale of their foreign investment, they can utilize a Section 1031 there.
Oh, so they have to be a U.S. taxpayer.
Somebody
Do
subject
it
to
in
U.S.
Europe.
tax. Right.
Okay, got it. Interesting.
So I was saying, so geographically, I think this is just important to highlight for those that might not be intimately familiar with 1031s. But so again, geographically, you can exchange anywhere in the United States or foreign for foreign. Interestingly enough, Puerto Rico is not treated as U.S. property for 1031 exchange purposes. Another method of diversification can be by asset class. So you may have somebody that owns a two-family or a townhouse in Manhattan and wants to sell that. Maybe it was purely investment, and they can trade into net lease property or a shopping center. In other words, you don't have to, and that's a common misconception, you don't have to sell a single family rental and buy another single family rental. That is not necessary. You can exchange for any other asset class. And lastly, by way of diversification is by number of properties. So again, common misconception is I am selling a single asset, I have to buy another single asset. That is not the case. You can sell a property for $5 million and roll it into 2, 3, 4, we can talk about identification rules and practicality, but you can diversify into 2, 3 or more replacement properties.
Right. So if a client of mine sells something for $3 million, they can buy 4 properties in Florida, as long as it equals to $3 million or more. Isn't that correct?
So, okay, yeah, you're kind of leading us into discussing some of the debt and equity requirements.
So, Eric, what are the debt and equity requirements for a 1031 exchange?
Yeah, so there are many misconceptions around this. The way that it works in order to fully defer all of the realized gain is that all of the net equity from the sale of the property must be sent to the qualified intermediary. And in order to fully defer everything, all of that net equity must be spent. And this is a critical important point, is that any principal balance of debt that is paid off on the relinquished property must be replaced on the new property. Now, it doesn't mean that a taxpayer is forced to take another mortgage. They can come out of pocket with new equity to substitute that debt. But for example, if somebody sold something for $1 million and paid off a $400,000 mortgage, they have $600,000 of equity. So they would need to spend the entire $600,000 of equity and replace the $400,000 of debt in order to fully defer their gain. Now, I wasn't factoring in the fact that there might be a realtor fee involved. There might be some other transactional costs, transfer taxes. So that would reduce the net equity a bit, but ultimately you want to spend all the net equity and replace the debt. And so that's where it also becomes important to understand what the adjusted basis is that we spoke about earlier to determine first and foremost that there is a gain that warrants doing an exchange. And so, to the spirit of misconceptions, oftentimes, again, people think they only have to reinvest the equity. Sometimes I hear people flippantly say, oh, I know we just have to buy something equal in value, equal or greater. Well, that's only true if you add the caveat that all the equity is also going into that acquisition. Because, of course, you can buy a replacement property, in my example, for $1 million, only putting $250,000 of the equity in, and buy $1 million property despite selling for $1 million, there would be a tax issue because they did not reinvest all of their cash, their equity in replacement property. So that is something, and oftentimes another misconception, people think they only have to reinvest their gain. So in this $1 million example, let's say somebody had a $300,000 adjusted basis, that means they have a $700,000 gain. So again, it's not a function of only reinvesting the $700,000 gain. That will not get you where you need to be.
Got it. So it's really important to speak to somebody like yourself. At what point does somebody have to speak to you? Say, for example, I spoke to an investor and they said, "Oh, I want to sell and buy something else." Should I have them reach out to you at that time?
Yeah, great question. So there's never a time too early to get me involved. I assist agents regularly on listing appointments to secure that listing because, of course, one of the common pushbacks, I've owned this property for 25 years. I'm going to have a huge tax issue. So to kind of spoon feed and be there as a lifeline for an agent to educate that taxpayer on the landscape of 1031, explaining how they can come out of the other side. Oftentimes somebody may not want to be a landlord anymore, right? So there are strategies where they can get into passive investment property. And so for an agent's part, of course, better to earn one commission than none, right? So, you can earn that commission on the sale. Maybe in a perfect world, you can find them replacement property and have another opportunity to earn a commission. But, like you said earlier, maybe they're selling in New York and they're going to buy something in Florida. Well, you're probably not involved in that anyway. Or there are some strategies that are technically securities that you need a broker-dealer's license to sell. So unless the agent also holds that, they're not going to earn a commission on that. But again, earning it on the sale is oftentimes better than not getting one at all. So for an agent's part, getting me involved very early is always helpful. But I, again, have to be involved in order to structure the sale as an exchange before that closing occurs. So once the property is in contract to be sold, I need to be involved. And I'm going to need to get a copy of the contract, the title report. I have a questionnaire that we have the taxpayer fill out for Know Your Customer KYC purposes for the bank. And if there's a corporate or trust entity involved, we would need those respective documents as well. We set up all the necessary 1031 exchange paperwork. We send it to the taxpayer along with their attorney and whoever's the settlement agent, if that may be different from the attorney. And then they have all the instructions, how the settlement statement should be completed, as well as where to wire the money upon the sale. Because as we mentioned early in the podcast, it's imperative that that taxpayer does not take that money and put it in their own bank account. That will blow their 1031 exchange. And similarly, if the attorney, if the accountant, if the real estate agent holds that money, that is deemed constructive receipt of the funds by the taxpayer, and that too blows their 1031 exchange.
Yeah, that was gonna be my next question. Have you ever known anyone that set out to do a 1031 and then they didn't hire you for whatever reason? It seems to me that would.
Unfortunately, once a month, I will get a phone call from a taxpayer, and I learned early in my career, over 18 years, the order of questions that I need to ask, because I walked somebody through the whole 1031, and then I said to them, "And when is your closing?" And they said, "It was last week." And, ship has sailed. I can't help them. Title already passed to the buyer. It was simply a sale. It was not structured as a 1031 exchange. So, yeah, it's important to get me involved early. And, we are talking about forward delayed exchanges, which are, let's say 95% of 1031s, a taxpayer is selling their investment first, typically because they need the money from that sale to fund their acquisition. But there are some more advanced structures, reverse exchanges, or where a taxpayer can actually buy their replacement property first and then later sell one of their existing investment holdings. So that's something that we are regularly involved in as well.
Oh, that I don't think I was familiar with. So if a buyer comes to me and they identify a $1 million property, what are the timelines?
Yeah, so let's
doing
talk about the
something like
timelines
that?
on a sale first, and then we'll just
Sure.
flip them for the reverse and explain some other nuances
Sure.
with it. So again, typically somebody sells their property first, so they'd engage our service before the closing takes place. We would set up all the documents. The attorney or settlement agent would have the account and trust that we established for the taxpayer, and they would wire the money into that. Now, that will, to your question, start two critical deadlines. The taxpayer will then have 45 calendar days to identify replacement property.
Yes.
Also beginning upon closing and title passing to the buyer, they will have 180 calendar days to close on one or more of their identified properties. So those are the critical deadlines. There are no exceptions. Now, having said that, sometimes there's an exception. There's no exception because the seller wouldn't sell it to them or the due diligence didn't pan out.
Right.
The only reason there may be an extension is if there is a federally declared disaster and that taxpayer is an affected party pursuant to a notice that is issued or otherwise can demonstrate they had difficulty meeting the deadlines. And that's generally going to be a CPA question to bless. So those are the deadlines. Now, and with regard to identification, maybe we should touch on very quickly. By far and away, most people use what we call the 3 property rule, and they can list up to 3 potential acquisitions without regard to the fair market value. So in an example where somebody sells something for $1 million, if they want to list 3 properties that are $5 million, that's okay. There's no cap to the fair market price value, but there is a cap to the number of properties. So they're limited to 3. If they wanted to list more than 3 because they don't know what they're going to buy, or maybe they intend to buy more than 3 properties, there is what we call the 200% rule. And that will allow them to list 4 or more properties. However, now we have to concern ourselves with the aggregate fair market value of those 4, 5, 10 properties, whatever it is. It cannot exceed 200% or 2 times their sales price. So in $1 million sale, they're limited to only $2 million of real estate. So unless they are trading down into, let's say lots of $100,000 acreage, lots of land, it's not something that's going to work. And, there are some other little nuances where it might be okay to make that work. There is also called the 95% rule. I'm going to spare that for purposes of this conversation. So that's the forward exchange. Now, a reverse exchange just flips those time periods and with some other complexities, because a taxpayer can't be on title to 2 properties at the same time and do an exchange with themselves. So before that acquisition, and again, it may be a function of you have a client and they were given this opportunity to buy a piece of investment property by the neighbor, or they were being very opportunistic, and all of a sudden the seller said, okay, you want it, you have 30 days to close. So they're not going to be in a position realistically oftentimes to sell their existing investment, what will be the relinquished property, before making the acquisition. So again, because they can't be on title to the properties at the same time, we have to perform a slightly different function from the qualified intermediary role that we do. We have to serve as what's called an exchange accommodation title holder. And in that role, we will sit on title for federal income tax purposes as the owner of that replacement property. And that will start a 180-day clock for the taxpayer to sell 1 or more of their existing investments. And they will have to identify what they're going to sell to us within the first 45 calendar days. So that's the reverse exchange in a nutshell. I'm like oversimplifying it a little bit.
Got it. So, it sounds like it's very important to have you in my back pocket when an investor wants to do this.
Yeah, certainly important to understand how you navigate, doing an exchange, regardless of forward or reverse.
Right. Because we don't want to have somebody call me or call you and say, oh, I just sold a property. And, guess what? I missed out and now I have to pay $200,000 of capital gains. And now I'm upset. We never want the fingers to be pointed at either myself or you. I mean, it can't be pointed at you, obviously, if they haven't talked to you or they've done it without you or myself.
Yeah. But, an agent is sort of the first line of defense. Oftentimes, taxpayers are not reaching out to their CPAs in advance of a sale. Oftentimes, they just call the CPA at the end of the year and say, hey, I sold that condo or single family that I've been renting out for the last 5-10 years. And, well, now they have a problem. So you really are typically the first line of defense with that. Obviously, the attorney should be having a dialogue with the taxpayer, understanding whether this is an investment property, suggesting that at least they learn about a 1031 exchange. An attorney may simply, and this becomes part of a conversation around the scope of their engagement, maybe they're just being hired to negotiate the contract and handle the closing, and that's it. And maybe they're not, going to issue or in a position to give any tax advice. So again, that's where it really falls on the CPA.
So I think it's very important for myself and my colleagues and other agents around the country to involve you when an investor calls us and says, oh, I'm thinking about selling. I want to know the value of my property. A matter of fact, I had somebody call me yesterday and say, I bought my apartment for $400,000. It's being rented out and I want to sell it for $2 million. So I don't believe that she's buying anything else. I think that these are her retirement proceeds for now.
Yeah. I mean, also, again, sometimes taxpayers don't want to be a landlord. So that's a conversation around other strategies that might get them where they want to be through an exchange. Sometimes they just simply want to take some money off the table, and that's okay. And maybe, or maybe they just simply don't want to own any other investment real estate, or maybe they plan to buy something for their personal use and it's not going to qualify. So it would be a situation where you're just simply not going to do a 1031. But again, to understand from the CPA, what does the gain look like? Do they have carry forward losses? There might be reasons not to do it. And that's okay. But it's great to have a conversation around it, to get a QI involved early. I'm always happy to be a resource, and my phone number's right here on my name here, so anybody can feel free to call me. There are some things I'd be remiss if I didn't point out. I am seeing a whole lot more seller financing conversations, and these do not play well with 1031 exchanges. So while a taxpayer may think, okay, we'll bridge the gap using some seller financing and I'm getting a little interest rate for some period of time, whatever. The issue is, and without getting into the full kind of conversation around it, unless the taxpayer is going to be in a position to fund that seller financing piece out of pocket, they are going to end up with a tax issue. It may be delayed under installment sale treatment for a little bit, but I recently had a taxpayer that offered a significant amount of seller financing relative to the sale price, and they are going to be paying a significant amount of tax. They did do a 1031 because they had such a low basis that they still benefited in just some of the money they were reinvesting and received from the buyer. But again, it's another reason to have a conversation early so that you can approach negotiations in the situation that's most favorable to the taxpayer. And that may be a function of not accepting that buyer, and maybe a buyer that's going to come up with their own financing, even though it might be slightly less or a bit less, because that taxpayer is not going to have as big of a tax issue.
Right. And it's also probably beneficial for the seller to engage their accountant as well early on, in addition to yourself.
Yeah, again, that's really a great starting point, so that they know what their adjusted basis is, so that they know what their tax liability would look like, because that's what you need to start and understand before anything.
Right, exactly. I mean, it's the more professionals and the more people that you have on your team, so to speak, the better, and the more educated that you are. And that's what I think is the most important part of this process, because nobody wants to be hit with huge taxes at the end of the day, at the end of the year. I certainly don't.
That's right.
So Eric, is there anything else that you would want to add to the listeners that we may have forgotten?
Yeah, no, I would just encourage people to reach out to me. I'm happy to be a resource for anybody that ever has any 1031 exchange questions. And I regularly conduct CLE classes for lawyers, CPE for accountants, and CE for realtors and agents. So always happy to be a resource. Just a phone call away. Don't hesitate. And thanks so much for having me, Heather.
Oh, and thank you so much for all of this abundance of information. I really appreciate you. Thank you so much.
Bye-bye.
You've been tuning into Heather Sells NYC with your host, Heather M. Cooper. You can find more episodes on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, heathersellsnyc.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.